this is an interesting topic because there is no single day that you open a newspaper and you don't read about a data center being set up at some part of the country. Recently, there was some big news from down south in Tamil Nadu, now also Uttar Pradesh. So many of them being set up. And this is a topic I think that would not also be watched here in this auditorium today, but also when this is sort of put up on social media and channel and YouTube, when this panel goes, I think you'll find a much larger audience simply because not that all of you are such good eloquent speakers, but the topic is also very interesting. This is powering of data centers, and I want to request Mr. MC Chauhan to start with his long opening comment where you give a...
Before discussing recent Honorable Supreme Court's judgment and data center, I would like to bring some facts into the notice of the August gatherings. Indian Railways are a statutory power utility since 1910. Railways have generated, transmitted and distributed electricity for over a century under law. It's not a mere consumer. What Supreme Court has said, no, it's not a mere consumer. The legal start has started since 1910. Section 3 of Indian Electricity Act 1910 empowered provincial governments to grant licenses to supply energy and lay transmission lines. Accordingly, licenses were issued to GIPR, now called Central Railway, East Indian Railway, Eastern and Southeastern Railway, and Bengal Nagpur Railway at that time. Now 3 railways are there: Southeastern Railway, East Coast Railway, ECR. Hence, Indian Railways are a statutory electricity utility since 1910. GIP Railway commissioned Thakurli Powerhouse in 1929 with initial generation capacity of 40 megawatt. At that time, this was the maximum capacity thermal power plant not only in Maharashtra but in whole India. In whole India, there was not a single thermal power plant of that much capacity. Additional 96 megawatt unit was added in 1950. Railways had built 110 kV dedicated transmission lines from Thakurli to Lonavala and Thakurli to Igatpuri to supply power to traction substations and 11 kV by 415 volt distribution networks. Power was supplied to traction colonies and hospitals, school workshops and stations, including private vendors in these establishments. Railways also maintained small coal-fired powerhouses at Jhansi, Kharagpur and Asansol since 1920. Operation flexibility was reinforced by the Indian Railway Act 1989, Section 11A and 11G, which explicitly granted the railway administration to construct, maintain and execute electric distribution supply lines and dedicated transmission lines for its own use. Workshop Code directs chief workshop managers to maintain powerhouses and distribute electricity to colonies and workshops. These are statutory rules with force of law. In May 1992, Union Cabinet approved that railways can avail direct power supply from central generating agencies out of 15% unallocated central share of power through their own dedicated transmission lines. Accordingly, NTPC power was availed in Delhi-Kanpur section from Dadri Thermal Power Station utilizing railways 132 kV transmission lines. This government-to-government allocation recognized railways as a utility with its own extra high voltage networks. Now, Electricity Act 2003, third proviso of Section 14 of Electricity Act 2003 clearly mentions that in case an appropriate government transmits electricity or distributes electricity or undertakes trading in electricity, whether before or after the commencement of this Act, such government shall be deemed to be a licensee under this Act, but shall not be required to obtain a license under this Act. On 10th June 2003, Railways had 1910 licenses, Thakurli Powerhouse since 1925, statutory codes mandating distribution, and 1992 Union Cabinet approved to have dedicated transmission lines. Thus, Railways is a deemed distribution licensee by operation of law. Section 43 USO applies only within its area of supply. Under subsection 3 of section 2 for railways, the area is railway land, colonies, stations, and workshops under the Railway Act 1989. CRC Order 197/MP/2015 dated 5th November 2015 declared that Indian Railway is a deemed distribution licensee under the Electricity Act 2003. Key rulings of order were deemed licensee status. CRC recognized railways as an authorized entity to transmit and distribute electricity for its own railway operations. Second, open access granted. Railways were granted the right to procure and wheel power across interstate and intrastate transmission networks to their traction substations. APTEL, in disposing appeal number 276 of 2015, supported CRC's decision of railways as deemed distribution licensee, and to provide open access to railways wide orders dated 16th December 2015 and 22nd November 2016. But what happened to APTEL in 2024? They have reversed their order. Situation was same. For over 100 years, Railways has run power systems under statute. The Electricity Act 2003 recognizes and continues this legacy. Statutory duty is to supply railway establishments and colonies. However, railways supply power to private parties also in their territory. With all these, I am quite surprised with the judgment of Honorable Supreme Court on 8th May 2026 against Civil Appeal number 4652 of 2024. The Railways does not pass muster as a deemed distribution licensee. Under Electricity Act 2003, despite clearly mentioned in the third proviso of Section 14 of Electricity Act, whole logic given by court is that railways consume power only for its use and don't supply power to other consumers. It's wrong. Railways supply power to other consumers also in its territory. Railways provide power supply to private vendors at stations, merchant rooms of goods sets, and to private shops in their colonies. During discussion of the case, justification of MES as a deemed distribution licensee was given by judges that they supply power to other consumers also in their territory. Same is done by railways also. So why railways have been singled out for the status of deemed distribution licensee? Recently, even data centers have been provided the distribution licensee status. Comparison of Draft Electricity Amendment Bill 2025, which has not even considered by Parliament, cannot be made with the Electricity Act 2003 already enacted by Parliament. In the court's arguments, similarly, any recommendation of the Standing Committee of Parliament cannot override any clause of Electricity Act 2003 which is enacted by Parliament. As per, again, Section 14 of Electricity Act, railways shall be deemed to be a licensee and shall not be required to obtain a license under this Act. Deemed distribution licensee distributes power within their defined boundary. Court has compared railways deemed distribution licensee with other state distribution licensee, which is not logical. Railways are already bearing the burden of passenger subsidy amounting to more than rupees 60,000 crore per annum. With this court's judgment, all power utilities will start loading various surcharges, including cross subsidy to railway taxation tariffs, and the judgment of court will affect all sectors of economy. As with high electricity tariffs to railways, transportation tariffs of all commodities, whether raw material or finished product, will increase and ultimately leading to high logistics cost. This goes against the PM's Gati Shakti National Master Plan to reduce logistics cost and to enhance India's manufacturing competitiveness across the globe. Indian Railways is the public utility of national importance and common man's transport. It is a backbone of the Indian economy. To provide distribution licensee status to data centers and taking away of deemed distribution licensee status of railways, which is already provided in Electricity Act 2003, does not follow the natural law of justice. Thank you for being here.
Thank you for your opening comment and some really interesting points you made on the status of railways and also the Supreme Court judgment. I'll go to Senior Advocate Sanjay Sen for his comments, also on his reactions to what Mr. Chauhan has said.
One caveat, I've appeared for the state governments of Odisha and Bihar in the Supreme Court against the railways. So that caveat I have to... The Supreme Court was interpreting provisions of the Electricity Act. So that's the very narrow compass in which we have to see. If you look at the proviso of section 14, certain specific exceptions carves out were made for DVC. Appropriate government is also mentioned. Then somewhere in the Electricity Act, it says atomic energy, railways and consumer protection, they will stand on a slightly higher footing or superior to the act in terms of. So railway had a recognition not as a deemed licensee directly, appropriate government possible. That was the issue. Both the appellate forum and the Supreme Court held it to be appropriate government. But being an appropriate government does not automatically make you a distribution licensee because of a previous judgment in Sesa Sterlite, which says although you can get a deemed licensee status, but you actually have to distribute power. So the universal supply obligation, section 43, all that will come in. So Sesa Sterlite was a single unit SEZ. So as a SEZ, you are a deemed licensee. But because it was a single unit SEZ, there were no unit holders. They did not get the status of a distribution licensee because there was no distribution. They were consuming itself. They also had banks, they also had canteens, they had ATM machines. So all that was explained, but the Supreme Court Justice Sikri's judgment, he said no. So they were required to pay cross-subsidy surcharge for taking power from Wesco, the Reliance company in Odisha. That's the precedent to this. So railways, the Supreme Court held, had made 2 attempts after 2003 to introduce themselves as a deemed licensee. Both attempts failed by parliamentary amendments. 2 attempts to amend failed. In the recent draft, they have called themselves as consumers. The recent draft Electricity Act says that over a period of 5 years, you will reduce cross subsidy and railway comes in that. So that was the draft, obviously can't become the law, but the Supreme Court took it as a statement of fact. It's a fact because that's how the government itself is interpreting railways. And so the 2025 draft that is circulating itself says. So
Can I react?
no, I'm just,
No draft is.
draft is not the law. It's a statement of fact. You don't need to then try to amend the law twice if you're already a part of the law. You don't need a special amendment to bring you in if you're already part of the original 2003. The attempt to amend went against railways. Why was the need to amend? The other issue, which also was bothering, the Central Commission does not have jurisdiction over distribution. How could it make a declaration? Distribution is a state subject under our system. Why was Central Commission getting into declaring a status when distribution subject is not with them? Transmission and generation, 79. So these were technical issues. So today, the debate is over. There is a judgment, the debate is over. Only option is a parliamentary amendment. Bring it in, you are home. Don't bring it in, suffer.
I have a question
There is
for
no
you.
debate.
By listening to you, the 1948 Act had caused certain actions to be taken. Thakurli he mentioned other places and all. Don't they have any sanctity?
Whatever was there was
No, my
examined.
question, let me finish. So are you saying the 2003 Act just...
2003 Act is a Reforms Act.
Yes.
It, first of all, it repeals everything in the past. So it goes. It's a clean slate. It's a reform legislation. So there was lobbies, DVC got themselves in. DVC became a deemed licensee.
Understood. My question is, supposing a contract was signed under 1948 Act, and then the period of the contract comes into 2003 Act. In the 2003 Act, that contract is null and void.
There's a repeal and savings. All acts done will be saved.
Under which
Except
section?
In the 181, 182,
181.
185.
Also, under section 14, there was a period of 1 year given as a sunset period
Yes.
to carry on your activities under the erstwhile
Then
contracts. And then everything had to be aligned to the Electricity Act 2020.
Yes.
2005. 3.
what happened to the trading license margin?
I think we are reading Electricity Act in very wrong way. The appropriate government is defined.
No,
Central government for railway defense. It's very clearly given. State government for other sectors, but for railway and defense, appropriate government is central government, that is Ministry of Power. And Ministry of Power has notified.
No,
Okay. So we cannot, some judge cannot tear the Electricity Act which is enacted by Parliament.
It is
I'm
not
sorry
some,
to say.
it is not some judge, it is a Supreme Court.
Whoever is there. That's another thing.
Chauhan Sahab.
SEZ.
Hello, Chauhan Sahab.
It's a Supreme
Let's discuss this.
It is a Supreme
Try and
Court
discuss
judgment.
it in a rational manner.
It's a Supreme Court judgment.
It's
So
a-
we are bound by it.
In fact, Mr. Chauhan, I'll come back to you again once the opening comments are over.
It's not over. Railways cannot compare, you have mentioned SEZ.
No, they can bring an amendment.
Just a minute, Military of Engineering Service, MES, and railways are at par.
Correct.
MES is supplying, distributing electricity only in source, in their jurisdiction.
There is a
They are
notif-
not supplying
Outside.
beyond Dhalakua.
Ah.
So similarly, railways are doing SVMR railway colony, barber shop,
It
or
was also-
everything. We are supplying electricity. But beyond our SVMR railway colony, we are not supplying electricity like MES.
Correct.
So,
So
This is
you're,
also
you're
exempt.
supplying to civilian consumers also within your
So
jurisdiction.
that's why I'm
The
telling,
notification.
nature law of justice is ignored here. Nature law of justice is, if rule is for me, rule is for others
But-
also. It cannot be for two different persons.
Appreciate your point. We'll go to Abhishek Monoth. He is a partner at JSA Law Firm. Good to see you, Abhishek. And please
Tarun.
give your opening comment.
So, essentially carrying from where Mr. Sen left in terms of the attempts made by railways to bring in these changes through a parliamentary amendment. There are only 3 doors through which a person can enter into the distribution business under the 2003 Act. One is in terms of an application for the purposes of grant under section 14 and 15. The second is an exemption which is being granted under section 13 read with section 5, and that's for the purposes of rural electrification. And third is provisos to section 14 where there are deeming fictions which are specifically enlisted. All of these arguments were analyzed before the Supreme Court, where Supreme Court held that merely having a distribution system is not enough. You also need to have a sale of electricity. And effectively, what railways was doing was there was no sale of electricity, and thereby they were classified as a consumer, eventually liable to pay cross-subsidy surcharge and additional surcharge for power that is sourced on open access. Now there is no fourth door which is available as on today.
No. Before you go there, in railways,
Yes.
there are platforms where there are, I have seen shops, canteens, this thing, who are not part of railways, who are getting electricity from railways.
Right.
So now, since when does consumer be allowed to sell power? Or are we going to disconnect
like
the electricity of all these guys?
I think you have not seen Bilaspur. You go to the Bilaspur railway colony, full market is there.
I would-
Platform, and that railway supply the power to.
I would love to agree with both of you.
I think
But today
no,
our
what
agreement
is happening in railway,
will not override the
you
Supreme
can-
Court
That's okay.
judgment.
That's okay.
effectively.
We are not.
Chance nahi hai.
No, we are not going in.
Unless
for-
you make an amendment and get a clarification.
I think
If
the
Parliament-
interesting point is this.
Government of India is there, railway is there. You should get an amendment done.
And in,
Anyway, review
And-
petition has already been filed to the Supreme
Sure.
Court.
John Saab, please. Yes.
I think the discussion is in context of both railways judgment and data centers.
I think we should move to data center
So
because
on the data center aspect, it's a very interesting discussion. Railway has a distribution network, but the Supreme Court has held that it's not a distribution licensee, and therefore, as a consumer, it is entitled to pay cross-subsidy surcharge and additional surcharge. On the other hand,
Okay, one small question.
I'll take an
One
example.
small.
I
Abhishek.
am asking one
Why- ओ यार एक मैं बात तो करने दो यार चौहान तुम बहुत एक्साइट हो जाते हो चिल करो. My question is the railway stations and platforms which have got these shops and other places where they were getting electricity through the distribution network, which the Supreme Court says is not enough. Are you saying now that the consumer railways is going to give power to the bookshops as a consumer?
Yes.
And that's not allowed? It's a violation of the Act? Since when do consumers start selling
So
power?
distribution
single
merely-
point
single point supply.
Single point supply is possible
As a
under a
bulk
supply.
consumer.
It can happen in cooperative society buildings. It can happen in
Malls.
Single point supply.
Okay,
Now
go
I
ahead.
come in-
Because if there are distribution licensee, no way in the past was an ARR filed and the tariff of supply to that consumer was never determined by the commission. The metering was not as per the CEA guidelines. So those issues were also considered.
Okay.
Now,
I-
now,
Data center.
now,
I
now,
just-
now,
See,
now,
for
I-
panelists and knowledge, no, it's not over. CRC and APTEL has asked railway, what is your jurisdiction area? And this is approved by CRC. Your jurisdiction area is your railway territory. So distribution, you are distributing your railway territory. In our territory, if suppose some consumer asks connection, we will give. Now I am again telling, in KK line, Kotewal Sakrandul line, where 1982 I was posted there, even traction power supply we were giving to this private shops because no electricity was available. Can you imagine? I think it is not knowledge of the judges what railways are doing. And CRC and FTL, this is in writing 2015. They've asked, this is your jurisdiction area and your jurisdiction area. You would supply to other consumers. And that's what we are
हो
doing.
गया ना.
point well taken. Now we'll allow the next uninterrupted 10-12 minutes to Abhishek Munot to complete his opening comment. So next 10 minutes, nobody interrupts you.
Correct. Now, the interesting aspect is a fortnight before the Supreme Court judgment came in, there was a circular or a government order which was issued by the government of Andhra Pradesh for Google, where effectively they said that they want to grant a deemed distribution license status to Google for the hyperscale data center, 1 gigawatt hyperscale data center, which is proposed to come up in Visakhapatnam. Today, Google owns no distribution network. We don't know in terms of whether there is going to be a sale of electricity or not. And as a consumer, it's been taken off the status of a consumer and been granted a deemed distribution status through a government order. Correct? Now, as I said earlier, there are 3 ways to get a license, a distribution license. One is a deeming fiction, but that has to be statutorily available. Whether a government order can grant a deeming fiction or not is something that needs to be tested, which Supreme Court slightly touched upon in the Railways judgment as well, and said that the government orders can't override statutory provisions. Then we come to the government of UP, which has now passed various notifications and government orders. The latest one has been issued today. And they have stated or notified that a group data center or a data center park can be qualified for or can qualify as a distribution licenses, and that area of supply has deemed to be the area of supply under Rule 2 of the 3C rules, as we call it. Basically, essentially what the rule says is that if you are going to apply for a grant of distribution license, then there has to be a minimum area of supply, that qualification criteria that you need to meet. And after the judgment of the Supreme Court in 2022, the rules were amended where the appropriate governments were given the authority to re-notify it from a revenue district or a municipality to a smaller area of supply. And that is what the government of UP has done, essentially to enable a data center to go and apply for a license, a parallel license, to the regulator. And the regulator under section 14 and 15 would then grant that license. So the question is whether this is the right approach in terms of a data center to go and apply for a license, or whether a deeming fiction by a government notification is to be seen. The other challenge, essentially from a distribution licensee perspective, is that you are taking out a big consumer from the system who contributes to the cross-subsidy surcharge element of it. So whether the distribution licensee is going to be impacted by this sort of an action where the data centers are going to be now deemed distribution licensees under the Act. Effectively, again, the twin test has to be put, where you have to see whether they own a distribution network and whether eventually there is sale to multiple consumers within the data center park. If it's a captive data center, it may not qualify as a distribution licensee. So there is no one rule fit all in that sense. The third aspect is also whether these data centers want distribution licenses. Because as per my understanding, there's only one data center which has applied and been granted a distribution license in Uttar Pradesh, which is the Hiranandani group. And I haven't seen any other application that is being made despite there being measures taken by the government. Essentially, if the data center today are carrying out the business of distribution, then it's more of a process of regularization rather than a grant in that sense. So these are the important aspects that all of us will have to look into, and it'll be interesting to see this into play. Because effectively, as per reports, for example, Google is a 1 gigawatt data center, essentially consuming half of the electricity of Mumbai on an annual basis. Today, globally, data center consumes about 1.5% of the total electricity generated. And in 2030, that number is going to be somewhere close to 3% of the global electricity production. So these are power guzzlers, and the entire balance has to be in terms of how the distribution licensees, which are already impacted, is balanced with granting distribution license status to data centers. So that's my opening comment on it.
Thank you for that detailed opening comment. I'll go to now Dhananjay Sahai partner at Kapala for his opening comment on the topic of today.
Yeah. Thank you so much for giving me this opportunity. Hello. Yeah. Thank you so much for giving me this opportunity and very valuable insights by everyone. And I'm going to build on what Mr. Manot was saying, which is I think one of the most important aspects of discussing powering data centers is that the fact that they are essentially hyperscalers, and they're going to cause a disruption in the global electricity demand, energy demand very quickly. Certain experts have termed this as a hockey stick moment, that where all projections of the past of what global energy demand is going to be is now having to be reconsidered, and policymakers are constantly thinking about how they'll meet this demand. And that sort of brings us back to our Electricity Act, which when it was drafted and conceived, it is unlikely that they were at that point of time thinking about how they would deal with such a sudden hyperscaling, sudden skyrocketing in demand. And when we consider that aspect from a sort of policy perspective as to what the legal architecture of the Electricity Act has been, and try to understand the Railways judgment of the Supreme Court, I think where the crucial distinction is that the Railways judgment was dealing with a sort of apparatus in the country of the Railways, which had been in existence for about 200-300 years already. The demand that the Railways generates for electricity, the way it distributes, is well known. It has been studied, and projections had all been made. Whereas the data center is a major disruptor, right? And it's something very novel and very new that policymakers are having to contend with. It's also interesting that in this entire environment, it appears that India has taken a position of trying to attract investment in data centers. Many countries are not trying to attract investment, but we are. And many states, obviously Uttar Pradesh, Andhra Pradesh are important examples, are enacting policy to attract them. And a part of that incentives package, the basket of incentives that are being given to technology companies to come and invest in data centers here, includes certain concessions on the electricity regulatory architecture. And that's where this discussion is interesting, because unlike other sort of facilities that would be deemed discoms, which would once you take them out of the network, they could very well affect the revenue of the existing discom. They will not be in certain conditions be able to contribute to the CSS pool. Data centers don't actually exist. This itself might be the policy incentive that brings the investment of data centers here. So as of right now, there's no net loss that is happening to existing discoms, because those discoms are not right now. There are no data centers that they're supplying electricity to. So that's a factor that we need to consider, that if we remove the incentive that is being given to data centers of being deemed licensees, would these data centers, would they like to invest in India at that point of time or not? Because the alternative is that, like as Google that is trying to do in Visakhapatnam, in the absence of certain incentives like that, might want to move their data center to a different state or to a different country like Vietnam. So when we have to, and we have to consider this as an overall sort of argument, that in the interest of this overall state gaining in terms of revenue, tax revenue, and employment generation, would it be feasible for us to redraw policy to the level where we can allow something like a data center, which may otherwise not fall within the traditional criteria for distributors, to make an exception for them, so that we can attract investment in that? That's a decision that we have to take at a policy level. And what I think is also something important here is that I think that in the current legal architecture of the Electricity Act, something a hyperscaler like data center doesn't exactly fit in. It's not your regular high tension industrial consumer. As Mr. Manot was saying, that the 1 gigawatt one data center campus alone, I think when compared to the demand is somewhere around 70%, would be 70% of Vizag's peak demand. And then there's a qualitative aspect to this electricity distribution also, is that unlike in other industries, other establishments, you won't have off-peak and peak hours. You need 24/7 constant electricity supply. The standards of that are very tight and higher. And a disruption in that is not just a nuisance for that industry, it could make it commercially unviable. So it is understandable why a data center would be interested in ensuring that the distribution network is something that meets their standards. And in order to attract that investment, we need to be able to listen to that conversation also, while keeping the discoms on board. Because I think discoms also add valuable years of experience of dealing in this labyrinth that is the Indian energy sector of various different companies, regulatory bodies. But in order to be able to fulfill the objective of getting investment, the data centers concerns as far as infrastructure, the quality of electricity supply has to be taken into account. And I don't think that within the current architecture we are going to be able to accommodate it. Maybe we need to rethink in terms of special categories, some sort of exceptions to be able to come up with that framework.
Thank you, Dhananjay, for some interesting insights. I'll go to Mr. Chauhan now. Mr. Chauhan, in bits and pieces, you were able to get across your points, but now it's your turn to speak. You can take the next 12-15 minutes to completely lay out what you wanted to share with all of us. So would you want to take it from there, from your chair?
I will already mentioned certain points.
Yes.
We judges have not taken care.
Yes, you can highlight that, including, you said, different areas of the country where what...
Coming to the data centers consume high electricity. Not only high electricity, requires huge amount of water. Cooling water. We have shortage of water, whether in Mumbai, and we are mushrooming, increasing data centers like anything. Why we don't install the data centers under sea? What China has done to ensure that cooling, proper cooling, and your drinking water, they are installing data centers under sea. Similarly, in Vizag, we have put data center under sea because there are going to be huge shortage of water. Mumbai is already, there is a huge shortage of water, and we are mushrooming data centers like anything. Now, regarding, we have to increase, okay, data center is okay, but you see, underlying spirit may be something else. This time will tell. Who will be benefited getting distribution licensee status of data centers? I think already I have read in some papers. I don't want to disclose the name. This private party will supply power. Had they not been given distribution licensee status, he would not be able to supply. So he would fill up the pockets. Okay. But this is unfortunate in India. Rules are distorted. Those who are distribution licensee more over than century, more than 100 years in the railway distribution licensee status. In every forum, even electricity act, but now someone will say, no, someone as Mr. Executive Power, he was here, there's some judgment, woke up in the morning and he will give some judgment. Without going to the details, that has happened. That's what I wanted to say. But again, we should be very careful of data centers about consumption of electricity, consumption of water. China has made very clear policy in there.
Point well taken. We'll go to Senior Advocate Sanjay Sen for his intervention.
I don't have much comment except what was made. I quite see that we are trying to attract investments. I don't even know the size of investments that come with data center, but must be something that's very, very big.
$15 billion for
Okay, $15 billion for Google is what? So these are obviously, but in terms of creation of jobs and how it helps the economy, by having a data center very well, but then how does it directly, indirectly, what are the ancillary services? How does it help the economy? That has to be seen, because if that's the kind of power you are required to, in terms of electricity, you need to generate that electricity, whether it's fossil fuel or renewables, or then you have to have storage, very strong storage architecture to give this 24/7 high quality power. Because I'm told, I was reading somewhere, there is a report by the Council for Energy, Environment and Water, CEW, which says that every time the quality of power goes down or suffers, the penalty and the compensation payout is huge, because the loss of data corruption, and that itself is a separate, how to what extent those risks are insurable. So a different set of issues will arise. So again, going back, whether the states have really thought through it, and how deep is that thinking in terms of generation, support of power. Possibly there are, like was rightly said, there were certain private interests at play, which is driving policies, possibly. private interests at play driving policies. But to what extent these are sustainable in the medium term, I don't know. I don't have much understanding of this yet.
Point well taken. I'll go to Abhishek here. And we go to our second question on SEZs. That can the SEZ model be extended to data centers?
The SEZ model had a very interesting background in terms of the SEZ Act.
The Vizag one is SEZ?
No,
Part of SEZ?
no,
No.
no. So the SEZ Act has a very special provision, section 49 there, where it empowers exemptions for SEZs under other statutes. Unlike Electricity Act, for example, the exemptions have to be spelled out in the Electricity Act. But for SEZs or the developers or co-developers of an SEZ, they can be granted exemptions by the central government under the SEZ Act for the implications or applications of the other central statutes. So that is how a notification was issued in 2010, notifying SEZ as deemed distribution licensees by the central government under the SEZ Act. And that was eventually adopted under the Electricity Act under 14B, proviso to 14B, and then SEZs were exempted. So currently, as Madhuru stated, if a data center is in an SEZ, then the same SEZ deemed distribution license status applies even to data centers. But otherwise, then that deeming fiction has to be introduced by way of a parliamentary amendment. That's essentially how the SEZ model can be adopted.
Point well taken. I'll go to Dhananjay for his intervention on today's topic.
Thank you. So when you look at the SEZ model, I think there are certain interesting aspects to it. Firstly, that the deemed distribution license to the SEZ is available to the developer of the SEZ. And I think by successive judgments of Sesa, Sterlite and Sundew, it's become, the Supreme Court has said that despite having that license, the developer still needs to perform a distributive function and needs to fulfill the criteria of what would fall within the Electricity Act. The second aspect of that is that Sundew, I think, is very clear on the fact that when you are distributing electricity to yourself, you are still liable to pay the CSS, the cross-subsidy surcharge. Now that makes the conversation slightly interesting for me, because when you're looking at data centers and you're trying to attract them using financial incentives and saying we'll give you a tax break, we'll make it possible for you to not have to contribute to the cross-subsidy surcharge, it sort of will get hit by the provisions and the ratio laid down by the Supreme Court in these two judgments. And what is also then interesting is that now data centers also have a couple of there are a couple of types. The Google Vizag data center is essentially a one data center controlled by one company, which might end up, in the terms of the judgment, distributing electricity to itself. Whereas something where akin to what's happening in Uttar Pradesh under the policy, where multi sort of company data center parks can be established, that might be something that where the SEZ model might be slightly more directly applicable. So we will definitely need, in order to be able to accommodate, let's say, Google in Vizag, certain more carve-outs. I think that would definitely be required.
Point well taken. We'll go to Mr. Chauhan. Mr. Chauhan, you, in bits and pieces, you've tried to make a point that despite the Supreme Court judgment, Indian Railways continues to supply power within its jurisdiction. Supreme Court saying that it's a consumer of power. Is that what you were saying in your first intervention?
I was saying that Supreme Court judgment, in their argument they say, Indian Railway did not supply power to other consumers. That's wrong. Indian Railways continue to supply power to private vendors. Actually, Railways has some jurisdiction. This, while granting deemed distribution license status, CRC and FTEL in 2014-2015, they asked what is your area, and they agreed that within their area you are authorized. So what this Supreme Court said that beyond your area of supply. Sorry, in our area, what is in our area, we are supplying to private parties also, whether it is in stations, okay, vendors, all stations, whether in goods sheds, merchant rooms are there, these are private, Contractors, they come, they have their rooms, so electricity is supplied by railway. Similarly, railway colonies power is supplied to them. So that has not been taken care into their judgment.
You are saying they supply and raise bills and recover payments also.
Payment basis. Naturally, they supply power and they get the payment, railway get the payment. Okay. So, but this has not been brought into the judgment.
The household and the shops, are they billed unit-wise?
Yes.
The number of
Unit-wise. So, and even they have said that is wrong. Argument says railway supply power to electric traction and signaling. It's wrong. At each station, traction power supply, whether reservation centers, whether platforms, FOBs, supply points are given from traction power, so that customers should not find difficulty. Suppose there is a grid failure. Okay, first that grid code says first traction power should be restored. So immediately traction power is restored. So that railway station will not be dark. Passengers will not be in dark. Each platform have been given power supply from traction, FOB, and so vendors are also benefited with that supply. So whatever areas and territories there, we are supplying power to the.
Effectively, you are saying the Supreme Court judgment doesn't factor in all these factors.
It not, and it is very wrongly argued, I would say. They are mentioning draft amendment bill. How draft amendment bill can override the act which is enacted by Parliament? वो जब amendment आएगा तब देखा जाएगा. अभी से तो आप उसको नहीं कर सकते. उस बेसिस पे तो आप डीम डिस्ट्रीब्यूशन लाइसेंस रेलवे का नहीं बढ़ा सकते ना. It is very funny part. Arguments itself are totally. I think you can.
Abhishek wanted to come in and then
In what
Sanjay.
way they have given argument, it is totally, somehow I am not convinced. And nature of justice is not followed. Why I am telling? MES also supply power to in their area territory. But they have given, and that has been reinforced by judgment, that MES is okay distribution licensee status, but railways are not. So this is against nature law of justice.
Point taken, Sanjay Senmon, senior advocate.
I'm not joining issues at all. All I'm saying is that today the status has been defined by the Supreme Court judgment. So there's no, we can debate, but there's no point of this debate. Unless you bring in an amendment, I don't see Supreme Court reviewing its judgment. It heard the matter for over a couple of weeks, 2 weeks, I think. And there is no immediate, they very rarely review these kind of judgments because it's very thought through. So I can only expect that at some stage they can amend the act and clarify the position what railway is taking.
Mr. Sen, just one point.
Just I will like to react on this. No Supreme Court's judgment is totally, if it is okay, now it will be okay. I am telling one case, metro case, DMRC case. DMRC Supreme Court has given judgment. You say that DMRC has to pay to Reliance 1,000 crore and they have framed time limit also. Then they have gone to curative petition.
Correct.
Mr. Chandrachud said it's wrong. He has reversed the decision that DMRC will not pay a single paisa to Reliance, and whatever they have paid, that should be taken back from Reliance.
You're right, absolutely right.
So no judgment is 100%. It can be reversed. Similarly, this case also can be reversed.
This curative has set out a bag of pigeons that can never be undone, I think. This one judgment at every panel, somebody gets up and says, nothing is final.
Because it means that
No, I'm saying, I mean, you've had judgments from Shah Banu's onwards. You have judgments where,
But that were constitutional issues.
no, correct. So therefore, whenever you have a judgment which needs to be, to be removed or put back, the best and the simplest way is to amend the law.
Yeah, but
Amend
in a
the law.
commercial
railways-
arbitration, you sitting on a curative takes it to a different.
That's a different. That there are other underlying issues. Let's not get into that.
I think Abhishek was wanting to come in with.
Let's look at it from a different perspective. Do railways want to be a distribution licensee, or does railway not want to pay cross subsidy surcharge? why would you want to get into a business which is not your primary business? Because once,
Sorry,
just
we
let
are
me
in
finish
the
my point.
business.
You're not in the business of electricity.
Let me finish my point. Yeah. So essentially, with a distribution licensee comes a lot of regulatory compliances, where you have to get your tariff determination, where you have to have a CGRF, where you have to have all the other things that apply to a regular distribution licensee. The ultimate objective, as I understand, and I may be wrong, is non-applicability of cross-subsidy surcharge and additional surcharge when you take power on open access, because that impacts the operational cost of the railways. And for that aspect, there is an attempt which is being made under the draft bill, where in the next 5 years, they want to eliminate these cross-subsidy surcharges that will be applicable to railways as a special dispensation.
Along with certain industries.
Yeah.
I think Mr. Abhishek has not listened my first 5 minutes speech. We are more than 100 years distribution licensees. We are building 132 kV transmission line. We are building thermal power plant. In 1929, 40 megawatt. In India, not a single thermal power plant was besides railways a thermal power plant. So we are in this business. We are in the business, and Indian Electricity Act 2003 has confirmed it. Ministry of Power has
let me ask this Dhananjay, a lawyer's question. So if you go by the Supreme Court judgment today, is railways in contempt because it is continuing to supply power and raise bills?
I mean, that's an interesting way to look at it. I wouldn't go so far as to say that they are in contempt, but it clearly the Supreme Court has laid down the law to state that they would not be considered consumers under the existing Electricity Act framework. But there's something very interesting that Mr. Abhishek was pointing out on the cross-subsidy surcharge. He's right that there is going to be an attempt. There is a proposal to try and eliminate cross-subsidy surcharge for some industries, including the railways. But we've seen that in a lot of these cases, because electricity tariffs are a very sensitive political issue, that when the price of the electricity goes up or down, it ends up sort of affecting the end electoral arithmetic. I am somewhat cynical about whether this plan can be carried out, because I feel that as the time approaches for trying to eliminate it and trying to make sure the sort of other basket of consumers start bearing the price of the electricity tariffs, these kind of considerations tend to prolong these schemes. So what these schemes that you think will eliminate subsidy in 20 years, then can sometimes continue for 200 years also in some parts of the world. So I mean, as far as that is concerned, even though the legislative intent at this point seems to be to eliminate it, I'm not sure when it comes to implementation where that's going to be. But similarly, I think going back to data centers, I think that also is one of the reasons why data centers would be interested in getting a deemed distribution license for themselves, because it then affects their bottom line, the profit margins, by not having to contribute to the CSS pool. As I earlier said, I think the only distinction is that right now railways is contributing, because if it is defined as a consumer, it's been consuming electricity for a long time, therefore it will be contributing to that, whereas a data center which is not in existence is not a part of this arithmetic. Its existence might actually hinge on certain financial incentives, like being allowed to stay away from the cross-subsidy surcharge.
Point well taken. I think Abhishek, and then we'll take a question from the audience, but please complete, Abhishek.
There's still a way today to get out of the CSS and AS obligations by contracting captive power, by investing into power plants and procuring captive power, right? There is still a legal way to get out of this. The problem is what happens to the network, whether they have a distribution network, the existing data centers. If you look at some of them, they essentially have a distribution network in place and also are supplying electricity and charging for it. So the problem doesn't lie at the CSS and AS alone, is also the activity, a license activity which is being done without a license. So therefore I use the word regularization in terms of the activity which is being carried out. Essentially for data centers is something that needs to be looked at.
Point well taken, Mr.
This draft amendment bill, what we are talking, I think Mr. Haridwar is not here. I was associated with the electricity bill 2000. Same clause was put in there. Mr. P.R. Kumar Mangalam was Union Power Minister. Unfortunately, his death took place, and it was going to be discussed in that monsoon session of Parliament. It is delayed by 3 years. Electricity Act. So that clause was deleted. This progressively that cross subsidy would reduce. Electricity bill 2000 says it was put in that clause, but it was when Act was enacted, it is deleted.
No.
So this similarly fate of this amendment
No,
will
no,
be
I'll tell
like
you.
this. It will be deleted. It will never happen.
No, what happened was 2003 Act had the word that cross subsidy will be eliminated progressively. The word was progressively eliminated. 2007, when the UPA government was there, the support of the left parties, the word eliminated was replaced, was dropped to reduced. So 2003 Act said progressively and then eliminated. The word eliminated got eliminated to reduced. So they said cross subsidy is a historical anomaly which needs to be corrected. It's not a virtue. It had to go with time.
Point well taken. We'll take a question from the audience. Gentlemen, you wanted to come in? You can take this mic.
Law is a complicated business, and I'm a technical man. But I would suggest to the railways, pay your 1 rupee and keep business as usual. But I work for the World Nuclear Association. My name is Ahmed. And Mr. Chauhan, you are very well informed because the international consensus is that power to these data centers probably will come only from nuclear, largely from nuclear, let us say, from SMRs. And there are proposals that some of these AI centers should be on the seacoast and should be underwater, and that power could be supplied by underwater SMRs or ship-based SMRs. So I think on the technical side, the electricity acts perhaps will be more related to captive power. That's what I would feel it would eventually end up, or merchant plants which have excess power, captive as well as merchant.
Are there any underwater operative parks supported by a nuclear power plant?
Not yet, but they are barge supported. In fact, the nuclear, there are about 400 reactors sailing above water, and we don't know how many below water in nuclear submarines. So the technology and the economics is fairly well proven. And particularly if you look at it, the most difficult environmental condition for any power system is an icebreaker. And the Russians have a fleet of nuclear icebreakers, and they have been having that for many years. So some of this perhaps doesn't come in the public domain adequately enough, I think largely because we as nuclear scientists tend to communicate in our own atmosphere, or we tend to be too academic, less, but I think it's equally true of the law from my
It's a more
side.
controlled sector. I mean, it's not available to the private sector.
Send you. Ma'am,
No,
you
sir.
wanted to come?
In fact, there is a proposal in the United States for a lake-based. They will put it in the lake.
Point well taken. Ma'am, you wanted to come?
As a researcher, it's not often that I can get opinions from so many lawyers at the same time. I had a very specific question on the notification of the government of Andhra Pradesh, because one of the provisos there says that the eligibility under this deemed distribution license is they have to be 300 megawatts, but they can aggregate it from multiple areas. And the minimum area of supply is the premises of that data center. So one implication is that I could have multiple areas of supply and aggregate that demand and all of them will qualify for deemed distribution license status, and the area is non-contiguous.
Correct.
In my opinion, that seems like a very different business model and can have serious implications for the power sector in terms of what qualifies. I would really like your opinion on that.
Correct. So that's exactly what it provides. And this is unknown in terms of the Electricity Act, right? For example, having non-contiguous areas as an area of supply for one distribution license amongst different areas. So, in fact, there are some challenges now in Andhra as well, where they've hived off the agricultural load to a different company. And now there are a lot of objections which have been filed. in terms of stating that everything which is being defined under the Electricity Act, the exercise of granting a distribution license to the company where the business has been hived off is completely contrary to that. So yes, the Act needs modification, and the easier way is through a parliamentary amendment, effectively. Because even otherwise, the deeming status that has been given, according to me, has no value in law in that sense, and is vulnerable to challenge.
So yeah, one clarification I needed there. So anybody who gets a deemed distribution license, even an SEZ, would still have to apply before the regulatory commission.
Yes, so that was the Supreme Court judgment in Sandhu, where they said that if the regulation provides for it, then the application has to be made as recognition. By deeming fiction, you are a licensee, but that recognition has to be done by way of an application because the regulation provides for it. So Andhra, that regulation is common with Telangana, and Sandhu came from Telangana, so therefore that recognition, until and unless the regulator grants it, and that grant has to be then tested in terms of the Electricity Act, and whether a deeming provision under a government notification qualifies as a correct test for the purposes of recognizing it as a distribution licensee is the question that needs to be answered.
Even the way the SEZ was introduced was not a very happy, legally sound way. It came through the SEZ Act, which empowered the executive to issue a notification, which then became a proviso in the Electricity Act. Why not do it directly? You first went to the SEZ Act, empowered the executive to issue a notification, which notification then slips into the proviso of section 14B as a... So it's slightly convoluted. These are all open to challenges. So somebody challenges, things will appear, like railways. If nobody challenges, it's fine.
Similar situation with the RCO.
Yeah, these are issues.
The obligation of RPOs was then sought to be controlled through a different statute by the central government. And now these are before the various courts under challenge.
The BEE came in, the state regulators' jurisdiction was curtailed. So these issues are there.
I mean, I'll just add one little point to what they've said. I agree. I mean, there are several legal vulnerabilities to that the Andhra Pradesh order. If you go and study the structure of the way the Google data center is being, in the corporate structure, there is a pass-through entity which has actually been given the deeming license. And I think that is there to kind of try and subvert some of these and circumvent some of these like regulatory loopholes that are there, including the fact that if you distribute to yourself, you're still liable to pay CSS. So I think that might be one of the reasons why the license is going into a company which I think is called Radiant Infratech or Infotech, which is then going to supply to the data center. So that might be something interesting worth looking at.
Mr. Sen, under what authority would the railway be supplying power if this after the Supreme Court judgment? Just needed a clarity because
this is an area which is grey, but I'll try to give you an answer. We have some states and some under the supply code, you have something called a single point supply, where you put it in one place and then a particular premise, a mall or a
housing societies in UP.
You have a single point supply. It is not there in every state. Industrial parks in Punjab. So then you distribute. So railways typically is recovering the cost of electricity determined for the distribution company. There is no separate cost of electricity determined by the regulator for railways for supply to a consumer. Correct. Now these people who are getting power from railways are in the railway premises, have a relationship independent of supply of electricity. Not independent. It is a relationship first as a leaseholder or as a license holder of a railway property. They're sitting in a railway property, they have a lease or a license, they also get electricity. A consumer of a distribution company does not have a relationship with the distribution company. He's a consumer, standalone.
So, Mr. Chauhan, who does the tariff determination for consumer user in your jurisdiction then?
Nobody.
No, nobody.
Railway decides, say similarly military engineering services, MES decides.
Can't decide, no.
Can't decide.
Railway decides.
Under the Act can't decide. And just an interesting perspective to what Mr. Sen said. in terms of single point supply. Practically, that is how it's happening. But there's a very interesting provision under the removal of difficulty orders, as we call it under the Electricity Act, where the exception for single point supply was only created for supplying to residential premises, not for commercial or otherwise. So that's also a gray area in terms of whether the supply can be done at a single point for the purposes of supplying to commercial premises.
In Maharashtra, the regulator was able to overcome this by creating franchises. Now let's say MERC is in that World Trade Tower or whatever. That World Trade Tower is a franchise.
Correct. So all malls in Maharashtra
It's a
are
franchise.
under the franchise.
They overcome this through two judicial orders.
Because otherwise then you require a distribution license to do it, and then you have to get the notification by the state
franchise.
government.
Franchisee case, Jalgaon franchisee.
Correct.
Jalgaon.
Mr. Chauhan, Railways is not doing any generation, it's just procuring and selling power.
No, railway is doing generation also. I told you,
Doing generation.
1929, 1925, Thakuli Powerhouse, Mumbai suburban area, it was 40 megawatt. In India, not a single thermal power plant was of that much capacity. Okay. Now, Nabinagar, we have built a captive power plant of 1,000 megawatt. 1,000 megawatt.
So that is unlicensed, right?
That's captive power.
You don't need a license for generation, whether captive or otherwise. They can get into whatever generation they want to, nobody can stop them.
The only question is under what authority are they distributed?
Not allowed. Earlier captive power plant was not allowed. It is after 2003 Electricity Act, but railways were allowed in 1925 itself.
No, captive power plants were there before 2003 also, but under certain government notifications and order policies. Yeah, there were captive power plants before 2003 as well. The framework was formalized in 2005 and 2003 Act. It was
So, Mr.
introduced.
Chauhan, as things stand today, Railways is committing an illegality in violation of the Supreme Court judgment. That's what I'm going to ask you. Railways is committing an illegality in violation of the Supreme Court judgment.
No, railway
It is not?
No.
No, I'm just wanting an answer.
Not at all. Railway is not doing. But Supreme Court's judgment is biased judgment, I would say. It is not natural. Because MES it is something else, data center it is something else. And railway, mind it, it's common man's transport. Viksit Bharat 2047 when say $3 trillion economy.
We have no legal clarity. You are saying
If Indian Railway logistics.
you're making statements, but I'm saying, is it in if you give me a one-line answer, are railways violating a Supreme Court judgment by distributing second prices, giving power to residential areas and also commercial establishments?
No, railway is not violating Supreme Court's judgment. Not at all. No. That's all. One point answer. No.
You agree? No.
On a lighter note, there's no violation till there is the decision on it, sir.
Declaration of violation.
We will go to a round of closing comments of 1 minute each, where each of the panelists will sum up what you wanted to. Please.
In P2P trading and in vehicle to grid trading, which is already has been done also in parts, what is your position one by one?
What is the question? I haven't understood.
In P2P trading, what happens is, if I have a PV installed and I'm not using it, or maybe somebody else is using it, some microgrid type of thing happens. I supply to Mr. X, and through blockchain, the settlement happens. From his account, I get the money also. And similarly, this saves the overall system cost also. In the microgrid, inter-transfer happens in the microgrid itself. And if some electricity is to be, let's say it is brought from some other microgrid, and only that external wire is used to the extent, instead of transmitting whole electricity from main generating station or somewhere. So this provision is being made, and already experimental pilots have occurred in Delhi also, in UP also, and maybe in some other locations also. So this is called P2P trading. Similarly, vehicle to grid trading, this has happened in Kerala. To my knowledge, I don't know is it correct or not, but something like this, that vehicle battery is having charge extra and it is not running, car is not running, say, or bus is not running, it can supply during the time when, say, electricity price in the grid is, say, 10 rupees and it can supply and grid is stressed also. So there should be some provision overall, overriding all this to reduce the system cost and to help the consumer also. Instead of just putting some other charges, this, that charges, compulsory charges or legally involving those issues, some legal way should be there to reduce all the system cost also and the charges also. So what are you doing?
You know, the issue is the distribution licensee wants to retain a paying consumer. If the paying consumer goes out of the grid and gets supply from a source other than his, then that paying consumer, if he's contributing to the cross subsidy in that region, then that cross subsidy has to be recovered. That's the whole game. Because of cross subsidy, all these issues are arising. Because the surcharge is nothing but to meet the current level of cross subsidy. That's the definition.
So is the cross subsidy the basic thing or the
core
minimum
issue.
cost of electricity to the user?
The distribution licensee says when you are going away, there are other users, I am socializing the cost. So the benefit that you are giving to the grid, the contribution that you are giving to the grid, that contribution is getting lost. So I have to then burden that cost to the other consumer who is not part of your system. He's not part of your microgrid. So that consumer will bear the cost. So therefore, he's socializing his costs. He's revenue neutral. The licensee himself is revenue neutral. He gets his money from other consumers. If railway, what is the fight between the railways and the states? The railways think that cross subsidy is burdensome. It is going to definitely have an impact on tariff, railway tariff, right? The states' views are that if this, I'm talking about the states like Odisha, Bihar, if 300-400 crore agar nikal gaya, that burden will come on the consumer. That's the, whether it's an efficiency issue, inefficiency issue,
Yes.
that's finally.
Your rules to
Ultimately, on both sides, the consumers are going to pay for it.
That is what
Whether
I'm
a railway
saying.
consumer or an electricity consumer,
No,
the consumer
that is
going
what
to
I'm saying.
Correct. So it's essentially going to be both.
That is exactly my point is, system cost को ही हम लो ना कर दें, ये जो connected intra-grid या inter-grids, micro-grids, इसमें हमारी system cost ही लो हो जाएगी.
लो कैसे होगी ना? It's a cost reflective tariff that is what is been
cost
determined.
reflective tariff भी अगर determine करनी होगी तो उस वक्त सिर्फ उतनी ही grid को आपको strengthen नहीं करना पड़ेगा. जो inter surplus रहेगी उसी से adjust हो जाएगा.
No, what is the size of this microgrid which will have an impact on the overall grid today? What is the size?
And how do you coordinate everything?
On various circumstances.
No, I'm saying in terms, if it has worked somewhere, we'll have some economical data.
So in Orissa, they're doing it in Simapuri and all of those areas.
In several cases, they're doing it. If you see the today's news in US, the electric buses have been asked to supply power to the grid when the grid is stressed.
So decentralization of power is essentially what you're saying. They're moving towards that direction.
So if such rules and such
It's there. Decentralized generation is there. It's there in the act, but I don't know how far it's being followed.
so that in the act, there must be something also to keep the cost minimum to the end user. So that basic part of the act is being violated by all this cross subsidies and all.
Cross subsidy is a political issue. Let's face it. It's a political issue. You know, when you have your agricultural load, which is unmetered, horsepower based, then part of the inefficiency, part of the agricultural load is your inefficiency.
I understand
It's
the
management.
political issues, the legal issues also, but I am saying, can we not have something like where all these issues are minimized and the least cost is
In
the
a
primary factor?
in a utopian world, yes.
In a
But
real
it's difficult
world,
to have it in a regulated sector today, right? Because the various stakeholder interests have to be balanced.
Because if you go and see the agricultural load in
Consumer
various...
is also a stakeholder.
Correct.
No,
Don't,
correct,
think that,
but consumers are different category. The agricultural consumer and the person who is part of the microgrid are completely different set of consumers.
but they are helping these persons contributing to the microgrid are helping in.
But he's getting
it's a political issue.
But he's getting free power. He's not paying for it.
It's a vote bank.
The agriculturalist is getting 6 hours of horsepower-based tariff on a monthly basis, not per unit. He's not paying per unit. So he's not in your economic system. He's paying on a monthly basis
So
based on his...
for that, it should be metered and the
Correct.
state should
That's a
subsidize
political.
it.
That's the political call. We had...
There's a statutory provision for direct subsidies under
he
the
is
Act.
telling right. When rules were made, that rules were made like this, state government have to put some amount for cost subsidy in their budget.
It's in the-
They should not surcharge to other consumers. That was made in the rule, but
It's in the Act also.
unfortunately it is not happening.
It's
They
in the
are-
Act also.
it is, but they are not putting, they are surcharging to other consumers, but that should not happen. Rules say it should not happen. State government should provide from their budget for cost subsidy, that 200 crore, they give from their budget. They should
Provisions
not
which are to be given
rely
priority
for
should
other
not
consumers.
get deprioritized by these legal.
That's what he said. It's a political issue eventually.
Anyway, now Mr. Sen has answered why court has given this judgment about railway. Railways are treated milking cow from state electricity board. This is unfortunate. Article 287 of Constitution of India says that railways tariffs should be less than industrial tariff by minus taxes, but not a single state electricity board has implemented that decision, and railways are being charged more than industrial tariffs. They are not even following the Constitution of India. So all state, when the CRC and FTL has granted that railways are deemed distribution licensee, all state electricity boards meet together, put together, and whatever they have gone to the court, that milking cow is goes from our side. That's why they influence judges in judgment.
Chalo, that conversation is outside the panel. One final question and then we can proceed towards ending.
Actually, I would really like to hear your opinion on what Mr. Manoj said. Like, what if it is gone captive? What is stopping railways from going on captive?
No, we are having captive power generation. Nagar captive power generation.
Instead of going on new distribution license or open access, those are the two alternatives. Why not go completely on captive, especially with a new captive?
Because you see, captive power generation ultimately it costs money. Okay, so with 1000 mega power plant already we have commissioned in Navinagar, but you cannot commission everywhere. When Electricity Act given that provision, and Mr. Sen has mentioned that you go to the parliament. When act is enacted by parliament, provisions were both Lok Sabha, Rajya Sabha, and president has given approval. वो आप उसको तो रिवर्स कर दिए तो फिर से पार्लियामेंट
Consumers are allowed to buy power from some supply direct under.
Even railways is allowed. What's stopping railways, right? The beauty of captive is that you only have to invest 26% equity. You don't have to buy or own an entire plant to get captive, and that 26 is of 30% of equity that is capitalized in that power plant. So essentially, the investment for 1000 megawatt is not. You are effectively paying it over a period of time in tariff by way of tariff, right?
SECI and PTC can be SPVs or railways.
There are multiple ways of looking at it, but as today it stands, it's only theoretical, the discussion whether they are a distribution license.
Now we'll move to a round of closing comments, 2 minutes each, so everybody can sum up what they said today on the panel. We'll start with Mr. Chauhan, Mr. Sanjay Sen, Senior Advocate, Abhishek Manoj from GSA, and then Dhananjay. Quickly, Mr. Chauhan, if you can start. Your closing comment for the day, very quickly, 2 minutes, then we end the panel.
Okay, closing comment is that somehow Supreme Court's judgment is not natural law of justice, and data centers, okay, these have been given encouragement, but technology should be taken care of. They should produce. Ultimately, it was thought earlier, they would generate their own renewable energy. Data centers would be allowed. They should not procure power. They should generate their renewable energy, because renewable energy production would go up in India. Then similarly cooling. Cooling is the major because it requires huge amount of cooling. So that we should put data centers inside the sea, not so that, because we are already having scarcity of water, whether it is in Telangana, whether it is in Mumbai. So we should take care of this technology. That's
Point well taken. Mr. Chauhan, senior advocate Sanjay Sen. Closing comment.
I think we have debated enough. I think it's time for coffee.
Abhishek Manot, closing comment.
Just one line. Effectively, any promise by the state of a deemed licensee status is just a promise. It's not a license. Okay. So that aspect we have to be clear of.
Point well taken.
And if these are acted upon, then there are a lot of vulnerabilities that are going to be highlighted, and each of us will be in court for one guy or the other, defending what the state has promised.
Point well taken. We'll go to Dhananjay Sahay for his closing comment.
I think the overwhelmingly large conclusion is that cross-subsidy is the main sort of agenda that everyone's trying to circumvent and try to attack. I think that the fact that cross-subsidy affects the bottom line of lots of stakeholders in the whole conversation is essentially what drives these special incentives to try and get data centers or railways, etc., within the distribution network or not. And I think as far as data centers are concerned, given the fact that they're so large and so demanding in terms of the power sector, we will have to rethink our entire architecture to be able to accommodate them if we are going to go ahead with the government policy of wanting to bring them to India. Of course, there are very good points for not wanting to bring them also, and if the government takes that view, that's a different story. But in the policy framework, we need to take certain reforms.
Sir, just one question if you can permit. The
topic last, then we end.
The topic is very interesting and I've been following it up. Suppose today some investor wants to take a decision, capital investment decision to go for, DCs. Given the railway scenario and the kind of thing, how should somebody should take a call, investment decisions?
Every decision you have to work out on the existing regulatory regime. If one thing that the investors are worried about is regulatory uncertainty. So therefore, one is at a policy level, you will look at things, but then you have to go beyond policy and look at what is the regulatory system that is in place. So investments are made in that fashion. There will be some risk which you cannot eliminate. So when you have to factor that risk in your overall cost. So in anything that's evolving like data center, there will be risks. And again, like I've said, the state in which you're operating, also there's no national level policy. In data center 2020, there was an attempt to make a national level policy. It was never notified. Subsequently, it is in the state level now. So you have to go every state and see which is the most beneficial and where you can be assured of certain amount of regulatory certainty going forward.
Point well taken. Ladies and gentlemen, I enjoyed moderating the panel. I hope you also liked it. Give these gentlemen a huge round of applause. I would like to thank Mr. Chauhan, Mr. Sanjay Sen, Senior Advocate, Abhishek Manot, partner from JSA, Dhananjay Sahay, who is partner with Kappa Law. Thank you for joining me and sort of making this panel very interesting.
Before you sign off, we must wish Abhishek a very happy birthday.
Happy birthday. So that's one more round of applause.